Your daughter gets into a fight at school. Nobody is seriously hurt. The school could handle it internally. A suspension, a call home, maybe counseling. Instead, the school resource officer files a report. Your child is arrested. Juvenile court gets involved. She spends 2 weeks in detention waiting for a hearing. You think the worst part is the juvenile case. Then release day comes, and ICE is waiting inside the facility. That is the part many families never see coming. Across the country, juvenile detention facilities are becoming transfer points into immigration detention. Not always because a teenager was convicted of a serious crime, sometimes because of a school incident, a probation violation, a misunderstanding, a low-level arrest that never even becomes an adult conviction. And for Black and Latino families, especially in neighborhoods already heavily policed, this overlap between juvenile justice and immigration enforcement is becoming one of the most dangerous blind spots in the system. Here is how it works. First, understand the timeline. A child gets arrested or referred to juvenile court. They are booked into a juvenile facility or intake center. Information gets entered into databases. That information can reach federal immigration systems. ICE places what is called a detainer. Then, instead of going home after release, the child is transferred into immigration custody. That entire process can happen quietly. Sometimes parents do not learn about the detainer until the transfer already happened. Now, one important distinction: a juvenile adjudication is not the same thing as an adult criminal conviction. A lot of families hear the word delinquent and assume immigration consequences are automatic. That is not true. Juvenile court operates differently from adult criminal court. In many immigration situations, juvenile adjudications are treated differently than adult convictions, but that does not mean the child is safe from ICE, because immigration enforcement does not only rely on convictions. Arrest records, fingerprints, intake information, police reports, and database alerts can still place a teenager onto ICE's radar. That is why the first contact with the juvenile system matters so much. Now, let's talk about the term families keep hearing, 287G. A 287G agreement is a partnership between ICE and local law enforcement agencies. In plain language, it allows local agencies to help with immigration enforcement under federal supervision. People often think this only affects county jails, but in some places, juvenile systems, detention programs, probation departments, or agencies connected to youth custody can become part of the same cooperation network. Here's what that means in practice. Without a cooperation agreement, ICE may have to independently locate someone after release. With deeper cooperation, the facility itself can become the alert system. Release dates can be shared. Immigration status checks can happen internally. ICE can be notified before the family even arrives. That turns juvenile detention into a handoff point. And this matters because many families still believe juvenile records are automatically private and sealed. Sometimes parts of them are, but intake systems still collect enormous amounts of information: name, address, date of birth, country of origin, family contacts, fingerprints. In some jurisdictions, that information connects to federal databases almost immediately. Now let's talk about detainers, because this is where confusion becomes dangerous. An ICE detainer is not the same thing as a deportation order. It is not automatically signed by a judge, and it is not always mandatory. A detainer is usually a request from ICE asking a facility to notify ICE before release, or hold the person briefly so ICE can take custody. That small window changes everything. A teenager thinks they are going home. The family thinks release is happening, but the release becomes a transfer. This is why parents sometimes arrive at a facility and hear the words, "Your child was released." What they are not immediately told is released to who. Now another critical point. State law matters. County policy matters. Facility policy matters. There is no single national system. In some states, local agencies are restricted from honoring ICE detainers without judicial warrants. In other states, cooperation with federal immigration enforcement is aggressively encouraged or even required. Texas and Florida, for example, have passed broad anti-sanctuary policies that increase cooperation. Meanwhile, states like California, Illinois, Colorado, and New York have stronger limitations in some areas. But even inside protective states, policies can vary county by county. One county may refuse certain ICE requests, another county nearby may cooperate fully. So families cannot rely on assumptions. You have to verify locally. And here's the difficult reality. Most parents do not know which system they're walking into until a crisis already starts. Now let's talk about the pipeline itself. People hear the phrase school to prison to deportation pipeline and sometimes think it is political language, but there is a real sequence behind it. School discipline becomes police contact. Police contact creates a record. That record creates data sharing. Probation and detention create monitoring points, and custody creates the easiest transfer opportunity for ICE. That pipeline affects Black and Latino youth disproportionately because those students are already more likely to be suspended, searched, arrested, or referred into juvenile court for the same behavior. A hallway fight becomes assault. Disrespect becomes disorderly conduct. A school incident becomes a court case. Then immigration consequences attach themselves to the juvenile process, and families are left trying to navigate two systems at once. Now, another distinction families need to understand. Release from juvenile custody does not necessarily mean release home. That misunderstanding traps people constantly. The release date can become the transfer date, especially if a detainer was already filed. That is why communication with lawyers matters early, not late, because once ICE takes custody, conditions change fast. Immigration court does not provide guaranteed public defenders. A teenager may suddenly face deportation proceedings without legal representation. They may be transferred far away from home. Phone access becomes harder. Family visits become harder. Documents become harder to gather. And many immigrant teenagers do not fully understand the legal process they are entering. Now let's talk about what families can actually do right now. Not abstract advice, actual steps. First, if your child has unresolved immigration status, start organizing documents before any crisis happens. Birth certificates, passports, immigration paperwork, school records, medical records, proof of time living in the United States, family contact information. Keep copies together because detention systems move quickly, and families who can produce records quickly usually have more legal options. Second, if your child enters juvenile court, immediately tell the defense attorney this: I need immigration consequences reviewed before any plea, admission, or agreement. Use direct language. Do not assume the court automatically considers immigration consequences. Some juvenile defenders understand this deeply. Others do not. Third, ask specifically whether ICE has placed a detainer. Ask in writing if possible. Email creates a paper trail. Questions matter. Has ICE issued a hold request on my child? Will the facility notify me if ICE contacts you? What is your detainer policy? Do you honor detainers without judicial warrants? Those questions force clarity early. Fourth, teach teenagers one basic rule during police or intake questioning. Do not volunteer immigration history without legal counsel. Young people under stress often overshare because they are scared. That information can follow them through multiple systems. Fifth, if release day is approaching, treat it seriously. Confirm the release time beforehand. Ask whether any holds exist. Have multiple adults present if possible. Document names, times, and conversations. If the child disappears into transfer, details matter later. And if ICE already took custody, move immediately. Locate the child through the ICE detainee locator system or by contacting the local ICE field office. Do not sign immigration paperwork without legal review. Ask an attorney about bond eligibility and immigration relief options. And one more thing families need to hear clearly. Preparation is not panic. A lot of parents avoid these conversations because they are afraid speaking about immigration risk somehow attracts attention. But silence leaves families unprepared during the exact moment speed matters most. Community preparation matters too. Schools matter. Local elections matter. Sheriff policies matter. Juvenile facility policies matter. Parents can request discipline data from school boards. Advocates can demand written notification policies for ICE contact. Communities can push counties to end 287G participation because these systems do not operate in isolation. The same neighborhoods over-policed by schools and police departments are often the same communities most exposed to immigration enforcement, and the consequences spread beyond immigration status. When systems normalize secret transfers, weak notification standards, and aggressive data sharing for immigrant youth, those practices affect everybody inside the system. Black families should pay attention to this too, because expanded surveillance infrastructure rarely stays limited to one population forever. This is ultimately a story about information. Families are losing children into detention pipelines partly because they never received a clear explanation of how the machinery works, what a detainer actually is, what 287G actually means, how a school incident can become an immigration issue, why county policy changes outcomes, and what questions to ask before release day arrives. So share this information early, before the probation check-in, before the school arrest, before the intake interview, because once the handoff already happened, every hour becomes harder.